Welcome everybody. And what we'll do is we'll just start with a quick introduction. I think Jim and I both know a lot of folks who are on the phone, but I'm sure there are people we don't. So Jim, why don't I just hand it over to you, do a quick introduction. We'll come back to me and then we'll start.
Sure, thanks, Dave. Jim Richards, folks. I'm the principal and founder of Reg Tech Consulting. I've been doing that for about 2.5, almost 3 years now. And it's just financial crimes related consulting after a sort of a 3-decade career as a BSA officer at a couple of large banks here in the United States.
Yeah, thanks, Jim. My career is not quite as long as Jim, but almost. I've been in AML. I started in AML before it was AML. Back then it was BSA. Late 90s, I've had various roles, including being a BSA officer at a national bank. I've been in consulting. I've owned a reg tech company myself. And so now I'm with Risk Canvas, part of Genpact, and happy to be here today. In fact, I was thinking this morning before the call today that the last time Jim and I were together, it wasn't a webinar, it was in person on a panel. It was 2005 at the ACAMS conference in Florida. So 16 years ago. Things have changed a lot since then. And I think, for those of us in AML, I think things are going to start to change a little bit more, probably over the next few years. So why don't we start off, B, why don't you go to the next slide and we'll just talk a little bit about what we're going to share today. Okay, so a couple of things I just want to get out on the top here that, obviously the Anti-Money Laundering Act, for those of you who have read it, have read summaries of it, Jim has published a great summary of it. It's 250 pages of legislation. We're not going to cover that in 45 minutes. That's not our intent. Instead, what we wanted to do was pick out a few areas that we think are particularly interesting and focus on those. And those are going to be what you see here in front of you. We're going to talk about the Corporate Transparency Act, or beneficial ownership, as most of us know it. Then we want to talk a little bit about what FinCEN, the new powers they've been given, new budgets, more people, what Congress expects of regulators in FinCEN. I think there's some changes there that are really going to impact financial institutions. And then we'll round out the 45 minutes with a discussion around modernization and technology and innovation, something that we read a lot about, both in the financial crime press, but specifically in this law, there's quite a bit that focuses on that. So why don't we go ahead? So again, Jim, why don't we talk a little bit about how does the law itself, again, it's 250 pages, there's hundreds of provisions. For those of you who think, well, is all this going to go into place right away? Jim, can you just share with everybody what it is and how it is that the law actually ends up, on the desk of an AML officer having to do something?
Sure. Thanks, Dave. Yeah, this is, as Dave said, this is legislation. This is sort of the first step in a multi-year process that we're going to have. As Dave mentioned, it's almost 250 pages long. It's 5 titles, 56 sections. But again, it's the legislation. And legislation is really what needs to be done or what is expected to be done. How is it to be done is left to the regulations. And regulations are going to take a long time. So for example, in the Corporate Transparency Act section, FinCEN has a year to get the regulations in place. So it's going to take some time. Think back to the Patriot Act. And again, Dave and I are around at the time. The Patriot Act was passed in October of 2001. We didn't have regulations until 2003. And then we didn't have regulatory guidance in the form of the first BSA exam manual until 2005. So it really took 3.5, almost 4 years for the industry really to understand what it needed to do, what the regulators' expectations were. So I think we can probably expect kind of the same thing here as well, Dave. It's going to take time. And so it's really business as usual for most AML officers right now, but knowing that things are going to be moving at us pretty quickly over the next year to 2 years.
Yeah, I would agree with that, Jim. And one thing I also thought about when I was reading the law and comparing it to the Patriot Act was how much of the Patriot Act seems to be geared towards specific things financial institutions need to do. Here, customer identification programs. And there was just, as an example, there was just a lot of financial institution specific direction. My interpretation of this law is more that the mandates and the requirements are more put upon government agencies, FinCEN, regulators, DOJ. And when reading that, I wondered if there were AML officers and AML professionals out there that might mistakenly think, oh, well, this doesn't really apply to us. This is more about what FinCEN needs to do, more about what the functional federal regulators need to do. But the point I'd like to get across is that many of those things, maybe most of those things that the government has to do, those are going to cascade down onto financial institutions. Quick example, FinCEN has to create something called an exchange where they staff it with financial crime investigations experts. They're going to be pouring through database data, SARS, CTRs, and they're going to be doing their own investigations, helping other law enforcement do investigations. Well, obviously, the exchange, that group at FinCEN can't do their job if they're not getting quality SARS, all the CTRs that should be filed. So we're going to talk more about that specifically, but just sort of the frame to help finish framing the discussion that Jim started. It's going to take some time. Don't misconstrue all of these new requirements put upon government agencies as somehow not impacting you as a financial institution.
Definitely. And thanks, Dave. Sorry about the technical difficulties there, but it looks like we're up and running. We did just poise a poll to the audience here, with so much to cover in this. So we want to see where we should really focus our time. It looks like a lot of the interest is going to be around the new expectations and around AML modernization. So let's keep that in mind kind of as we move ahead to this first piece. So really, when we talk about a Corporate Transparency Act, maybe Jim, I'll lob this over to you. What is really within the legislation regarding that? And is it really going to be an improvement for AML and CFT programs?
Well, I won't spend too much time on it since only 5 people find it most interesting. It's probably because it's most talked about right now. But the Corporate Transparency Act was really a response. Forms of it have been put before Congress for about 12 years now. So they've been trying to get it passed for a long time. It really comes back to, FATF was very critical in 2016 when they did their last evaluation in the United States. And they called the lack of a Corporate Transparency Act or a lack of a beneficial ownership regime a significant gap and a serious deficiency. And the former Treasury Secretary last summer, when he testified before Congress, even called it a significant national security issue. So we were due to get it. But what we got with the Corporate Transparency Act was kind of watered down a little bit. And the biggest thing is that financial institutions can only query this database of beneficial ownership information with the consent of their customer. And so that's going to really limit the impact for financial institutions. But until this thing gets built, and FinCEN has to build this database, and it could take years for them to do it. For example, when they rebuilt their SAR database in 2010, it took 4 years for them to build that database. So it's going to take some time for them to build it. They have a year to do the regulations. So nothing is really effectively going to change for probably a year to 18 months. Banks are still going to have to collect and verify their own beneficial ownership under the current rules.
Dave, anything to add to Jim's point?
No, I think just to emphasize that last point that Jim made, that there really, I could be wrong about this, but the way I look at the law, I don't see anything that financial institutions should be changing regarding their beneficial ownership program. Maybe at some future date, and I think realistically, I agree with Jim's timeline, maybe 3+ or 4+ years from now, maybe there will be, I think in the law, they call for a FinCEN identification number. Maybe that would be something a business could provide, and that could accelerate the UBO due diligence process that banks have to do. I'm just suggesting that may be something. There's nothing specific in the law that says that would suffice for UBO information, and chances are, knowing our regulations, it probably won't. But even if it were, that's years away. And then Jim, I know this isn't the topic people want to hear most about, but maybe we could just finish it up. You were telling me the other day, because as a lawyer, you're able to read this legislation with much more vigor than I am. There's a lot of carve outs as well. Like there's a lot of corporate entities that even now, before the regulations are even written, won't have to actually register with this new database. Could you just tell everybody a little bit about that?
Sure. And I characterize myself as a recovering attorney rather than a practicing attorney. So, but yeah, the beneficial ownership rule that we're familiar with, there were 16 exemptions or exceptions to legal entity customer, which was the entity that you had to collect the beneficial ownership information on. With this Corporate Transparency Act, there's now 24 exceptions. So they've added a few. What have they added? They've added money transmitters. So money transmitters don't have to provide beneficial ownership information to this new FinCEN database, which is interesting because there's an assumption that because they already have to register with FinCEN and are already providing their beneficial ownership information to FinCEN, but they're not. They only actually have to provide their owner or controlling person, one person. They don't have to provide the beneficial ownership information. So that might get fleshed out in regulation. And then charitable organizations, 501, Section 501C of the Internal Revenue Code, those institutions, those charitable organizations, do not have to provide beneficial ownership information. The problem with that, though, is that those are those dark money pools that are contributing to political campaigns. So they don't have to provide beneficial ownership information. So there's a few shelf companies don't have to as well, so long as they're shelf companies. And then finally, they've carved out any entity that has more than 20 employees, more than $5 million in revenue, and has operations in the US. So Congress felt that those things can't be shell companies. So they were exempt. But the problem is they can be front companies. So I don't know what's going to happen at the end of the day. There's very few of these companies in the United States. They estimated it's about 2% of all companies. But I don't know why they carved those guys out, because those are front companies. Probably the best front company you could get. So,
yeah, not to be too cynical, but maybe sometimes our legislation actually tells the bad guys what they need to do. Anyway, so yeah, Sean.
Yeah, Dave, just keep in time. Yeah, let's get to this next piece. So now, I think this is a really exciting piece of the legislation, right? The new superpowers that FinCEN will inevitably have. Dave, maybe you take the first pass at this. Where do you see kind of these new powers lying, and what does that really mean for the folks on the call today?
Well, I think, in my opinion, I think it's the most significant part of the legislation. Now, it isn't one single part. It's a collection of many different sections of the legislation. But I think what my view of it is it's empowering FinCEN as we say here, sort of the quarterback of the US AML effort, or maybe some sort of more centralized control. And in particular, now it doesn't give FinCEN examination responsibilities. We're not going to see FinCEN people in financial institutions doing examinations. That's still going to stay with the OCC, the Fed, the FDIC, and the Credit Union Association. But one of the things that is going to happen, and this is actually going to happen by July 1st of this year, is the government's going to publish its new set of national priorities. And it's FinCEN's job to push those priorities out into the rest of government. Obviously let law enforcement know what they are. Obviously, law enforcement is going to have a lot of input into what those are. But those priorities, then, I think this is just something that those folks on the phone should be very attentive to. If I'm an examiner and I see that FinCEN has published national priorities, I'm going to want to see, how are you updating your risk assessment? Have you gone back now? Let's just say human trafficking. We suspect that would be a national priority. I would imagine a lot of banks on the phone might already incorporate that into a risk assessment. But if you didn't, I think you're going to have to explain why you didn't. So that's one example of where I see FinCEN, their new role, their more new power having a direct impact. Jim,
Yeah, no, you're spot on. And in fact, the legislation is very clear that the federal bank regulators are going to have to examine to those national priorities. And so again, it's like you said, it's got to be baked into your risk assessment, and you've got to adjust your program so that those national priorities are reflected in your program, in your policies, in your procedures. It could be a very, very impactful. But what it does is it really illustrates, I think, the overall intent of this statute, which is to really try to fight financial crime. It's less about sort of the pageantry of having a compliant program, and it's shifting us more towards really focused on fighting financial crime. So I think it's a positive change.
Yeah, I agree. And just thinking about too, in addition to the risk assessment, as Jim was mentioning, you got to put into your procedures things like customer risk rating. Right now, all of a sudden, you might have the government is telling you potentially this type of customer we consider a national priority. I think another word for that would be high risk. So if the government considers this type of activity, this location, this type of customer high risk, do you need to change how you risk rate customers? Do you need to now go back and do a retroactive rescoring of customers? By the way, I think the answer to that would be yes. So, I think too that maybe, Jim, this would help. I think a lot of criticism I've heard over the years from regulators is that risk assessments, and sometimes from AML officers themselves, who look at a risk assessment as just this one time a year thing. They do it, it gets looked at, they put it away until 10 months from now when they start it all over. I think this, though, helps sort of pull the risk assessment through into the rest of the program. And now there's this sort of national priority setting that says this is where every financial institution has to start. Now, where you go from here, that's your unique circumstance, but everybody has to have this, and we want to see it through your program.
Yeah, and it's going to be much more of a dynamic process. Instead of, as you said, it's sort of a once a year thing. You do it, you dress it up, you present it to the board, you present it to the regulators, and then leave it aside. So it's really going to be a big impact. So your risk assessment people, your risk assessment process, it's going to have to change with this.
So something else too that I think about new superpowers is the training, and Jim sort of alluded to this, and I may have alluded to it as well, but I want to call it out specifically, that in the law, the federal functional regulators are required to receive annual training. And in that training, I think it's interesting that, again, the law specifically says they need to receive training on patterns and trends. So criminal, financial crime patterns and trends. Secondly, why law enforcement sees AML laws and CFT laws as critical to their mission. And then they've added the effects of de-risking. So, Jim, I just want to get your thoughts on, regulators are going to be told these are the crimes that we're concerned about. This is why law enforcement thinks it's important. Oh, and by the way, maybe it's time to rethink this whole de-risking thing.
Yeah, I'm not too sure how amenable the FIEC institutions, the federal functional regulators, and the Conference of State Banking Supervisors are going to be to this sort of directed FinCEN law enforcement focused training. I'm not too sure it's going to go as smoothly as people would like it to. But again, it goes back to, why are we doing all of this? It's not about passing a compliance exam. It's about fighting financial crime. And so I think Congress really wanted to push that notion and push it down into the training to make sure that the people on the ground were getting the appropriate training. Because that's where you hear a lot of the gripes, I think, Dave, is that, Washington, D.C. says one thing and the regulators on the ground are examining very, very differently. And as far as the de-risking thing goes, this is, I think Janet Yellen talked about it the other day. It's really important, I think, that we, as we do fight financial crime, that we are very sensitive to and understanding of the jurisdictions that we're impacting and the groups of people that we're impacting and the businesses we're impacting. And there's de-risking is a real issue. It's a real concern. And I've always called it re-risking, not de-risking, because you're not de-risking anything out of the system when you're exiting a customer or exiting a jurisdiction. You're just moving the risk around and probably moving it to an institution that can't handle it well. So this is it's an important change, and I think a very good change.
Yeah. Great point, Dave. Sorry, I just want to keep us on track here. We got to give the people what they want, and it sounds like, based on these new superpowers, there's the pressure's on. So there is going to be new expectations, not only of the regulators, but it likely will trickle down to the ones that they regulate. So, Jim, maybe you can talk a little, or I guess Dave, let's throw this one to you. What should we expect from everywhere, from some of the bulge brackets to maybe some of the smaller community banks? How are these new superpowers going to affect what they need to do and what expectations these programs need to have moving forward?
Yeah, sure. Thanks, Shai. So I want to tee this slide up by sort of pointing out something that I found, get through 25 years or so in this. I remember when, I first started, it's just FinCEN and financial crime wasn't too much of an issue that you heard a lot about on Capitol Hill. And, someone who lives in the Washington, D.C. area, if something was happening, I might have been more likely to hear it, and you never really did. But I was sort of taken aback by some of the comments of the lawmakers of Congress in writing this law. These are quotes, by the way, the quote marks are from the senior Republican on the House Financial Services Committee, Patrick McHenry. And, what the larger quote here is the context is he's saying, look, I've been doing this job in Congress for a few years. I've gone to FinCEN. I've said, give me evidence, give me data that what you're doing is working. And all I get is a bunch of scary stories about, meaning, well, we're helping to stop this crime and that crime. And, how much does he express the will of all of his colleagues in Congress? I don't know, but I think he expresses the will of a significant number who's saying, look, if we're going to give FinCEN more authority, more money, more people, tell them to innovate, we want to see if all this AML stuff is working. So every year now, and from what I gathered, this hadn't really been done before, FinCEN is going to have to be submitting a report to Congress. And in that report, again, in the law, I think the quote is something along the lines of they want to see statistics and metrics on the use of SARs and CTRs, and they want to see specific numbers on how many arrests has this led to, how many forfeitures, and how many national intelligence actions has this led to. So I think, I'm curious about how Jim feels about this, although I think we're of like mind, because it gets back to what he's been saying is this seems a lot more about fighting financial crime than passing examinations. And if FinCEN is going to be told by Congress, prove that this stuff works, that's going to flow down into your exams and onto financial institutions. And I'm going to say that your suspicious activity programs are going to get quite a close look. And that might not be part of your program that's gotten quite an intense look over the last 3 or 4 years. So Jim, step off my soapbox there and hand it to you.
No, I'm going to jump right onto your soapbox because I've been barking about this for years and years and years. Because a bank filing a SAR is like a car company building a car. So we built 2,500,000 SARs last year. That's what the industry filed with FinCEN. We don't know whether the government, law enforcement, bought any of those SARs. We don't. It's those anecdotes that you're talking about, you have up on the screen, anecdotes of scary stories. We hear anecdotes from law enforcement. Yeah, they use the SARs all the time. FBI, 20% of their cases come from SARs, et cetera, et cetera. But we don't know. We don't have hard data. And the industry, needs to know how many of our SARs are being bought by law enforcement. How many are being used by law enforcement? Are they good SARs? Are they not good SARs? So this feedback, so DOJ, as you said, has to report to Treasury on the use and utility of the reports. They have to report to Congress. Treasury has to report to Congress. FinCEN has to provide law enforcement or financial institutions with feedback. This is huge. This is a huge, huge difference. We're going to know as filers of SARs, which of our SARs were effective, which ones were used, which ones were, and why were they used. This is going to inform our monitoring. Our monitoring is going to be that much better. But to your point, Dave, we're then going to be examined to it. Because so far, there's not a BSA officer out there that will say that they were examined on the effectiveness of their SARs, because they never have been. You've never been examined on whether you're filing effective SARs. You're examined on whether you're filing timely SARs. You're examined on whether the SARs have appropriate narratives, but never whether they've been effective. So that's going to be a big, big change for BSA officers.
So Jim, as a BSA officer, what should I be looking at in terms of how I should position our regulatory filings moving forward? Is it a data change? Is it a process change? How should we be thinking about it?
I think it's a bit of both. So if you're not already tracking the feedback you do get from law enforcement on your SAR filings, you've got to start doing that and build that into your system. And there's different ways you can get that feedback. Dave, you're familiar with that.
Mm-hmm. Yeah, so what this law, well, one way you can get feedback is subpoenas, right? If you look at your subpoenas, I would hope most financial institutions do this. If you don't, you should be. If you're looking, you get the subpoenas, you can determine, I think, with some reasonable level of intelligence that this subpoena was the result of maybe a SAR we filed. That's a good indication of an effective SAR. That's sort of a retrospective look. But I think more of a prospective look is part of the law is requiring FinCEN to publish twice a year a report on trends and patterns. I think that might even be the name of it. So sort of back to what Jim and I have been talking about. I mean, the government is going to be giving each financial institution or every regulated entity every 6 months the guide as to what they want to see banks' monitoring systems detecting. So if there's a trend of some sort of money movement to a certain part of the world, for example, and you're examined sometime and after that, you better be ready to show the examiners that, yes, we looked at that. We determined that we have existing scenarios that cover it. So we're good to go. And here's the process we went through. Or we determined we needed to add that type of monitoring to what we're doing. And so we added it. And here are the results we're getting. So I think what I see is a much more sort of up-tempo cadence. You've got the annual priorities being set. You've got the semi-annual reports from FinCEN. There's going to be, I just think, just a lot more continuous activity around looking at all of your detection, investigation, and reporting processes.
Yeah, and I think the other area that is we're going to see a lot more interest from the regulators, because we're getting it through this legislation, through FinCEN, is sort of the innovation and information sharing. So 314B, the bank-to-bank information sharing regime that we've had so far, really hasn't taken off. Hasn't been much interest from the regulators in sort of pushing banks to do it. But there's going to be more and more of it. And I think there will be an expectation that banks are doing more formal information sharing. They're forming associations or consortium of banks that are sharing information, and then doing it with better technology, with sort of innovative solutions. So that's also going to be a big change. And then, as we've got here on the slide, the formalized risk assessment process. So far, it's been regulatory expectations that you have a formal risk assessment, and now it's in the law. It'll be in the regulations, and there'll be a lot more scrutiny on your risk assessment process.
Definitely, Jim. And it sounds like this is a good segue to our next segment. Sounds like a lot of the expectations coming down from FinCEN are going to require these programs to be more agile in terms of how they update their programs, their monitoring logic, their overall risk assessments. We think AML modernization is an outcome of that. Jim, I think this is a very timely topic. Janet Yellen just came out yesterday discussing the need for modernization in the finance world and in the banking world, not only for the effect of financial crime, but also the underserved and the underbanked in the rural areas. Do you want to talk a little bit about that? I think it's a great segue here.
Yeah, so from February 9th and 10th, there was this public-private innovation policy roundtable, I think it was called. And it was hosted by the new Treasury Secretary, Janet Yellen. And it was 50 or 60 participants, public and private sector. And they were talking about sort of the use of innovative technologies across banking. But she really focused, particularly in her opening remarks, on the financial crimes aspect of it. She called the AML Act as a mandate, and these are her words, to renovate the framework for combating illicit finance. So she really called that out. And she talked about responsible innovation, which is sort of the innovation that we're using to try to fight financial crime in a little better way. But then she also talked about equitable innovation. And that is being able to make sure that the underbanked and the those that aren't as privileged are able to sort of embrace the new financial world, financial sector that we're building here. But I also saw that as a call to the smaller institutions who really don't have the resources to do a lot of this AI and machine learning and all this fancy stuff. We can't leave them behind as we're doing all this innovation. Bad guys will just go to the smaller institutions. So a lot of innovation, but we need to make sure that we're looking after the people that need looking after.
Great point, Jim. And Dave, what are your thoughts on what these programs can do to innovate? There's going to be a threshold of obviously maintaining the minimum standard, being in compliance, but there is this top-down approach of it's time to innovate, and we really mean it this time. So what does that really mean for the folks on the call today when they're probably getting demo requests from folks like myself and really just trying to make sense of all the noise of where the ROI lies and where they can really be more effective in financial crime prevention?
Yeah, so I've got a few thoughts on that. So first of all, I don't think we certainly don't want to convey the message, and I don't know if Congress cares whether or not they are or not, that we don't want to say that there's been no innovation in AML over the last decade. I mean, most folks on the phone have probably spent some time over the last 5 years looking at new software, new technology. But I do think in what, as you said, Shai, now the government is, standing behind everyone and pushing hard for that to happen. The government is pushing on the government themselves, and then they're pushing on banks. And particularly in the law, another part I found quite welcoming was Congress is telling the regulators that they need to put into the manual guidance, so it's not regulation, but guidance on how financial institutions can update their systems. What are the testing protocols? And as you're doing that, also what's the guidance to sunset, whether it's a scenario or a system, because everyone has been through the circumstance where they'd like to modernize some aspect of technology, but what they're looking at is some period of time where they have to run systems in parallel for 2 years or a year. That's expensive, not only in terms of money, but where do you get the people to do that? So maybe there's some acknowledgement on the part of lawmakers that the government needs to lay out specifically how that can be done. I think one interesting, so jumping to the next point, I think one interesting thing that I'm seeing a lot of in technology is this concept of modularized compliance. So when Jim and I first got into AML, well, first of all, there were the initial transaction monitoring systems were access databases, by the way. I remember seeing a demo for one in 1998 when I was at JP Morgan. But subsequent to that, with Search Space and some others that I think are now Actimized, there was this notion that you had to have one system that did everything, right? And they're usually expensive. They take a long time to implement. But the concept of modularized compliance is you can have something that does monitoring. You can have something else for case management. You can have something else for risk scoring. You know, there is interoperability even among the larger vendors out there and the smaller vendors. So people shouldn't be looking at this as, oh my gosh, I've got some $20 million 5-year project ahead of me. There's smarter ways to go about it. And that modularized approach is one of them.
Yeah, and on to the effect of computer science and analysis, can we talk maybe a little bit about the variance in expectations for the level of technology the type of institution needs, right? So if I'm a community bank, do I really need machine learning to be really effective at financial crime compliance? Or is that more of an expectation for the bank down the road? How do I determine what is the right level of innovation for my bank?
Dave.
Okay, so I think, well, not to sound like a regulator, but it all starts with a risk assessment. But I think in some cases it does. If you're a community bank, I mean, what's your risk? I mean, Jim, I think you were mentioning to me, you have a client who last year filed 14 SARs.
Yeah.
And hopefully every single one of them was good and effective, and those were the number they should have filed. I don't think there's a need for them to go out and start investing in bots and machine learning and new case management. Now, maybe for those smaller institutions, as we have here, number 3, this notion of pooling resources. If those of you in the webinar may remember back in October, I think it was 2018, the regulators put out some, I forget what the official, it's a memorandum where it said smaller or any institutions, but I think it was meant for smaller, can pool their AML resources, people, technology. So maybe that's a better avenue for some banks. Maybe even large banks should do that. Nothing says that major financial institutions can't do that either. So, you know, I think there's some opportunities there for banks to take smaller steps along the digital technology modernization path.
Yeah, and I think, you know, we're sort of enamored with all the machine learning, artificial intelligence, all of those terms. And really, it really all comes down to having good, clean, labeled data. So if you're a small institution and you are still, all your customer records are still sort of manual records, or they're somewhat automated, some manual, you can't spend 5 cents on machine learning because you're wasting those 5 cents if you don't have that good, clean, labeled data on your customers and your activities. So I would focus on the back-end systems to make sure you've got really good data, and then the computer science and analysis problem gets a lot easier. And to Dave's point, you don't need a lot of fancy stuff if you're a very small institution. But if you're getting up into that size, you do want to think about pooling those resources. I think the regulators in this legislation has given small institutions a green light, really, to pool their resources. So I think that's going to be one of the big changes in the next 3, 4, 5 years. We are going to start to see associations of institutions. It might be 10 or 12 banks in a local area that all get together, instead of each of them having 3 AML people. So that's 60 AML people between the 20 banks. They might be able to run on their programs with 20 people in total. The savings could be tremendous, and law enforcement is going to get a better product as well.
Yeah, Jim, conversely, what if we're looking at the other side? What if you're a top 10 financial institution? Is there almost an expectation that you should be leading by example in some of this innovation?
No, absolutely. And I think the big ones do have the ability, they have the resources to do that. And the regulators have the expectations that they are sort of using the cutting edge technology, et cetera. But to Dave's point, for them, even for those guys to make a big change, they've got to run in parallel. They can't turn something off while they're sort of piloting and testing something else until it's proven. And the regulators can be pretty tight on that. And you might have to run through a couple of different periodic cycles to ensure that it's not only effective, but it's sustainable. And then only once you can prove that sustainability can you start to turn off some of the other systems.
So Jim, that's a great point. It sounds like there needs to be some minimum expectation of initial increased costs with any innovation, but really it sounds like the benefits are longer term and much bigger. In terms of timing, folks, I do want to spend a little bit of time on our QA. We have a bunch of great questions coming our way for you all. Before we do that, just wanted to remind everybody on the call, if you do want to get your ACAMS credits, please email info@riskcanvas and we will send you a certificate, as well as if you check the chat, we have links to our website and social media channels. So I'm just going to pick through some of these questions here and see where would be probably best spent for our time. So let's see. Okay, this is a good one. So what is your insight on innovation regarding blockchain AML registries, know your vessel, UBO, SARS implications for financial crime, self-insurance, automated compliance, some of these more kind of new aged financial instruments? How is that going to change for some of those new kind of cryptocurrencies and digital currencies?
Well, I don't know. Oh, sorry.
Yeah, I mean, the one thing that dropped into the section on strengthening FinCEN was a whole bunch of changes to the definitions in the Bank Secrecy Act itself at 31 USC 5312. And it sort of codified the crypto type stuff for a lot of the definitions of a money remitter, monetary instrument, et cetera. So what has been regulatory expectation or even regulation is now part of the legislation. Where are we going to be? Where are we going to go with blockchain? I mean, blockchain's been a solution looking for a problem for about 10 years now. We're still not there yet. So I'm not sure if we're ever going to have AML, or in my lifetime, have AML registries based on blockchain. I think FinCEN's going to have enough trouble just standing up a normal one, let alone anything based on a distributed ledger.
Yeah, I don't have much of a different view than Jim. I think as crypto or digital assets become more common, I think we're in for a decade of a lot of friction between governments and people who want to use crypto. And I mean, I don't want to get too off field here, but I don't see governments giving up their power over the ability to control currency.
And it is sort of the fundamental argument of the day, right? Because the entire regime that we've had for 50 years is premised on the financial intermediary, which are the banks and money transmitters, et cetera, being the one that has the ones that have the obligations. And with decentralized finance and the disintermediation of finance, that whole concept is being thrown on its head. And that's why there is, as you say, Dave, that conflict that we're going to have, that we've had and will have for the next 10 plus years.
So with 1 minute left, folks, I'm going to throw one more at you, just maybe a speed round. Both Dave and Jim, let's get your thoughts on this. This was a pretty insightful question. What should we expect from some of the leaders in AML? Folks like, I think someone called out Daniel Pinto, COO of JP Morgan Chase. What should we expect from executive leadership at some of these banks? Should they be leading by example? Are there maybe their decisions and actions, are they going to be more scrutinized here with these higher expectations for how we handle financial crime in this new age?
Yeah, I think the CEOs need to step up, but just as important, the CFOs need to step up as well and start financing some of the innovations that the big banks are going to have to do. So it's great for Jamie Dimons of the world, et cetera, to step up and say, yeah, we're fully committed to financial crime compliance. But I think the CFOs need to step up and start cutting some checks to make a difference.
Put your money where your mouth is. Thanks, Jim.
Yeah,
What
and
about you, Dave?
I'll end with some of the thought I had earlier that sort of a good addition to Jim's answer, maybe a good round out here is I think it's incumbent upon financial crime officers, AML officers, heads of fraud, that you need to begin having discussions with senior management about the impacts, some of which we discussed here today. I think most CEOs, CFOs think AML and financial crime spend, other than cyber, that they spend a lot of money on cyber, but AML and financial crime spend is sort of on this, continuing downward trajectory. And I know, obviously, we're consultants. I don't want to sound, I don't want to sound crass here, and there's no connection. If I were an AML officer, I would be thinking, there might be some more investment we need to make over the next 2, 3, 4 years, and I should be having some discussions with senior management about that.
Yeah, and I would use the AML Act of 2020 as the reason why you need to be better fed and better watered from your senior management.
Well, guys, it sounds like we've had an insightful discussion. We have plenty more questions to answer. If you do have those, feel free to follow up on some of these social handles through our websites. Dave, Jim, it's been a pleasure having you guys. We hope this was a fruitful conversation for the folks on the line as well. We appreciate your time, and we'll see you at the next webinar.
Thanks, Jim. Thanks, Shai.
Thanks, everyone.